All right, everyone, welcome. My name is Bowman Hyden on behalf of New York University, our Technology, Innovation, and IT program, together with the Classic Liberal Institute, and with the help of Hoover and the Stanford IP Association. I'd like to welcome to the debate today between Professor Richard Epstein and Professor Mark Lemley. My colleague, Adam Mossoff, who's also co-chair at the Classic Liberal Institute in our program, will be the moderator. And so I hope you have a good day. We'll be ready for questions. So please, Adam, take it over.
Oh, well, thank you, Bo. And thank you, everyone, for coming to this fantastic event in which two titans of intellectual property law and policy will be debating the proposition, is intellectual property really property? Now, my name is Adam Mossoff, as Bo indicated. I'm co-chair along with Bo and Richard of the Technology, Innovation, Intellectual Property program at the Classic Liberal Institute. And really, as I mentioned, delighted to be moderating this debate. The general structure of the debate format will be that each of our debate participants will spend 10 minutes laying out their positions. They'll have 5 minutes to reply, and then we'll open it up to the audience for questions and answers. I am not one normally for long introductions of speakers. We live in a world in which we have a vast interconnected network of computers with massive databases of information. So if you would like to know more about our speakers, you can certainly look them up, Google them, Bing them. On the one side is Professor Richard Epstein of New York University School of Law, and Professor Mark Lemley of Stanford University School of Law. I will sit to the side because I suppose, in addition to a battlefield situation, I think one of the more dangerous places in this debate will be to stand between them. If you know each of them and how animated and engaged they become and get with the ideas, then that matters. And this is also, by the way, not just an auspicious date because of this amazing debate with these scholars, but it's also, for those who may not know, it's an auspicious anniversary. It's actually on this date in 1880, Thomas Edison received his patent on the first practical light bulb. And a patented innovation that had a tremendous impact on the world and our society. And so I think it is fitting that Professor Epstein and Professor Lemley are debating the foundational issue that has profound implications for both law and policy as to whether the patent that Thomas Edison received is a property right or not. So without much further ado, I will kick it off by turning the podium over to Professor Epstein.
Thank you very much. It's a great pleasure to be here. It's a great pleasure to go toe-to-toe with Mark, whose intellectual resilience and imagination I think is known to you all. I think it is my duty to actually start with a constitutional text, so I'm going to read it because I always forget it. To promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And so the question then is exactly how does this particular system work? And I think that you have to look at a number of words here to figure out what's going on. The first is the word secure. And the question is what kinds of mechanisms are going to be necessary in order to secure the various kinds of protection that are so important. And if, in fact, we say, in effect, that the Constitution allows Congress to pass and adopt any system of patent and then to attach any conditions whatsoever that it wants to the patented right that it gets, the rights in question are not going to be particularly secure. It also says in this particular case that what you have is an exclusive right. It does not say that you have a patent monopoly, and it's extremely important to understand why the difference between these two conceptions lies at the center of this debate. If, in fact, you think that a patent always confers a monopoly in the strong sense of the world, it means that there are no competitors who are there, and you're going to start to attract various kinds of regulations under the various doctrines having to do with common carriers, public utilities, and so forth. But an exclusive right, in this case an exclusive right to use and dispose of a patent, is no more the creation of a monopoly than a situation where you have a plot of land to which you have the exclusive right in use. So long as there are other close substitutes that are around, it turns out that an exclusive right is the foundation of a competitive economy. It does not turn out to be the foundation of some kind of a general system. So the question that one then has to ask is, when the legislature gets these things and it starts to make a grant, what kind of conditions can it impose and why can it impose them? And the first point I think to note is that the United States, when it is in the business of issuing patents, particularly in the 19th century, issued patents for two different kinds of things which were covered by very different kinds of rules. The first thing that it issues was patent with respect to land, and this is land to which it had absolute and indefeasible title. And under these circumstances, if you're the owner of a particular form of property, generally speaking, you can usually dispose of it on the terms and conditions that you see fit. Even that overstates it with respect to a federal government, because generally speaking, various kinds of trustee obligations are going to attract the things, so that the government as a public trustee cannot simply give away something for a song. What it has to do is to make sure that it gets some form of a respectable quid pro quo. But the limitations on government are even greater when you move from the situation with respect to land to the situation with respect to patents. There is not an arsenal or a collection of inventions out there which the government owns, like the land that it owns, which is going to start to give out. Instead, what happens in this particular case, the patent system is an acquisition system, much like the system for the acquisition of land. The only way in which you can get this stuff is to show that you have somehow or other occupied the various state which is described by your patent. And then, in effect, once you can show that you've done that, you are protected by a series of rules against infringement, which are the analogies to trespass. And with respect to the kind of patent that you have, it turns out the exclusive rights of use and of disposition allows for the creation of a secure system of rights by which these things can be licensed, they can be developed, they can be mortgaged, they can be transferred as part of the sale. And so that what happens is the correct way to think about a patent system is that what it does is once the patent is granted, it creates a system of rights which are as efficient and as powerful as those that you get in other areas. Now, there is one difference that one has to remember, which is intellectual property does not have the same characteristics as physical property, so that when you start to deal with it, generally speaking, are you going to demand that there be only limited terms, because what you're constantly trying to do is to trade off the ability to initiate and to invent, which does require exclusion, but that basically excludes other people from using it. And so what happens is after a limited period of time, something moves from the private to the public space. But ironically, if in fact you know that that transmission is going to take place, it only strengthens the case that during the period where the patent is in effect, that it starts to be treated as though it were a property right. Now, what is the way in which one tries to express this as a matter of constitutional law? I think goes as follows. The single most important unstated doctrine of American constitutional law, which is important on federalism issue and important on property issues, is the so-called doctrine of unconstitutional conditions. And what this particular doctrine says is that the government may have a power in order to do something, or it may have the power not to do something, but if it chooses to do something under these circumstances, what it must do is to do them in accordance with various kinds of conditions that respect the basic situation under the Constitution. In this particular issue, the central concern that one wants to worry about in virtually all of these cases is the issue of separation of powers, the question between what it is that a legislature does when it authorizes a grant, what the executive does when it makes the grant, and what is going to happen otherwise when it turns out that the grant has been issued. And the long-standing, until the recent rather lamentable decision in the oil states case, which came down a couple of years ago, I think is well captured in a decision called McCormick against Harvesting Company against another company. And it says, when a patent has received the signature of the Secretary of Interior, countersigned by the Commission of Patents, and has had affixed to it the seal of the Patent Office, it is passed beyond the control and the jurisdiction of that office and is not subject to be revoked or canceled by the President or any officer of the government. It has become the property of the patentee and as such is entitled to the same legal protection as everything else. That kind of sentiment is also repeated much more recently in the decision that the Chief Justice did in the case having to do with one in the Department of Agriculture. We're trying to talk about what it is that we think about when we think about as a patent is essentially a protected kind of right. So the question then is, if in fact you are going to start to think of this thing as a protected kind of right, exactly what are the kinds of protections that you're going to give? And it turns out these protections essentially have to come in two forms. The first of these, I think, has to come with the question of separation of powers, as I've met. And the second thing has to come with the question of the level of compensation and protection that you receive for the patent once this thing has been officially granted. And I think the clear implication of the McCormick case, which was the universal understanding in the 19th century, is what Congress can do and what the Patent Office can do is dither about as much as they want. But once they make a final decision, there's a bright line rule which says you have now made your work, and at this particular point, any effort to revoke or to alter, to interpret the patent is something which has to be done by the court. This is utterly inconsistent with the provisions on inter partes review, which are found in the American Invents Act of 2011, which essentially in various kinds of cases it says that we can try to bring these things back in order to try a second shot inside the administrative system under a set of rules which is so ramshackle and in many cases so utterly dangerous that not only do you have separation of powers issues, but you also have very serious due process issues, given the ad hoc way in which many of these tribunals can be put together and conducted. There are also serious process issues, since it turns out that since the inception, this has been largely very sympathetic to people who are said to be infringers, rather than to people who are said to be patent holders. I think it's extremely important to note that if in fact there is a just compensation requirement that attaches, that compensation requirement since the 19th century has attached in circumstances where it turns out that the infringer turns out to be the government, they can't renege on their grant, or any other kind of private party, and you cannot have yourself a robust set of rights if it turns out that what you have is a very questionable set of procedures that are done inside the administrative state. The usual requirement of due process is if you want to have a final judgment under these kinds of circumstances, what you really want to do is to make sure that these things are done inside a court, because at that particular point, what you do is you do preserve the independence of the three branches, and generally speaking, when it comes to the adjudication and the organization of particular rights, that is something which has always fallen inside the prerogative of the judiciary, and it is extremely dangerous as far as I'm concerned to say that the same people who are in charge of administering the system inside the administrative state are the people who could have ultimate powers with respect to their adjudication. Now the question then arises exactly, is this thing completely metaphysical? And I think the answer is really not. It is sometimes said, and rightly said, that patents are not a matter of natural law. That is, there are no particular rights that come out there. What you'd have to do is to have a kind of a statutory scheme in place. But I think it's important to understand that that scheme has the following characteristics, remarkably similar to that of ordinary property rights. What you do is you have to find a way to acquire it. And once you've acquired that stuff, what you do is you defend the perimeter and then exploit the middle. Putting the system in that particular form now means that property rights and intellectual property join correctly and indissolubly with other forms of property rights. The overall efficiency of that system is vastly greater than in any administrative system, where what you say is, if we grant you a situation, we can always take it back, we can always tailor the remedies. It cannot be the case that you're going to grant somebody the exclusive right to a particular invention and say, and oh, by the way, if anybody violates it, the maximum fine is going to be $10. You have to understand that the doctrine of unconstitutional conditions makes sure that the protection of intellectual property rights are secure, just the way the patent clause provides. Thank you.
Thank you. Professor Lemley.
All right. Well, thank you all for being here, particularly given the alternative upstairs. So the canonical image of property is land. Property is broader than land. It includes personal property, for instance. Henry Smith says it applies to things. But IP isn't things. And IP law is abstract concepts that give you legal control over what other people do with their own land and their own things. And that control is allocated by the government on an ongoing basis. Now, that's regulation. Right? Maybe it's welfare. You could say that the IP is a government subsidy for creativity. Right? We give you something that you wouldn't otherwise have had. But in doing so, we regulate what anyone else can do with their own property and with their own ideas. That doesn't mean it's a bad thing. Regulation and subsidies are good in many cases. But I do think it means that we can't assume, as property advocates often do, that it is inherently good thing. I learned as a debater in 7 years of high school and college that you need to make 3 points, so I will make 3 points. First, the factual circumstances of IP don't look much like property as we traditionally think of it. Second, the law doesn't look much like property. And third, from a policy perspective, those who treat IP as property are almost always doing so to make the law worse. Let me start with the first. The practical differences between IP and any form of what we think of as property are pretty dramatic. All right, so take the smartphone. The property analogy posits that there are something like 500,000 different little parcels of land inside this thing. They're owned by thousands of different people. Further, you can't tell whether or not you're treading on one just by looking at it. So the idea that there's a boundary or a notice that's signaled just is absent in that case. It fails completely. Many different people can own different overlapping bits of land. So unlike the land in the real world, lots of different people might own the same little piece of this thing. And the rights in this land will appear and disappear at various times throughout the world. And in fact, even if you set out and build a phone and you think, okay, I've somehow gone out and found all of the people with all of the rights that might or might not read on my particular phone, you still won't be okay. Because the government is in the business of creating new retroactive rights regularly because of the sort of 3 to 5 year period it takes to get a patent, and even longer than 5 years because of the period of time in which people can come back, file continuation applications, change their patents, add new patents, and so forth. Now, there's no way you could have licensed those. But too bad, if you don't stop selling your phone each time a new one appears, you're a trespasser. And as we'll see in a minute, you're a trespasser for whom the result should be the phone must be shut down. Right? We must grant you an injunction. Doesn't matter that you made a good faith effort to avoid infringement, that you read all the patents you could, that you made sure that you didn't do anything. This is a strict liability offense. If our land system looked like that, nobody would ever leave their house. And even because it turns out somebody's property rights might extend to your house because they overlap. Now, there are occasional boundary disputes with real property, but the level of IP disputes is hundreds, if not thousands of times as great. It's hard to figure out, actually, what percentage of all boundaries and properties in the real world turn into lawsuits. But you can estimate, I don't know, 200 million pieces of real property in the United States, so say 800 million borders, billions of transits every day across those borders. And we see occasional lawsuits where we can't figure out where the borders are or where somebody passed without permission. But we see very, very few such lawsuits. Contrast that with patents, where perhaps 10% of any patent that has any value ends up in litigation because we can't figure out whether it should have been issued in the first place or what it actually covers. Now, Richard talked about patents, but it's worth noting that other IP rights don't look much like real property either. The name of your customer, the religious scriptures of the Church of Scientology, the vibe and feel of a Marvin Gaye song, the fact that a robot in a blonde wig turning letters reminds people of Vanna White are not tangible things, right, akin to real property. Trademarks, I think, are least like property. The entire question of infringement of a trademark is a contextual one based on whether or not people are confused by the similarity of words, even if those words are independently created. So I don't think the world IP is trying to regulate looks very much like the world we think of as property regulated. Now, that world has its problems, right, as my examples indicate. But the doctrines we have developed to deal with those problems while creating legal rights are doctrines that diverge from the normal rules of property law. We don't make patent infringement a crime, which we do with the theft of property. We don't automatically grant injunctions to owners of the 500,000 little parcels. We don't disgorge the defendant's profits. We limit the damages that the plaintiff suffered by apportioning them among all the different contributors to value. That doesn't look much like a property, like a strict liability tort regime, right? One in which we just want to make you pay the costs you impose on others while minimizing the extent to which our IP system prevents you from doing what you otherwise want with your property. Now, other IP regimes do have a more property rule for remedies than patent does, though in none of them is there an automatic injunction. Copyright and trade secret law do have criminal penalties and disgorgement of profits, but that's because the conduct in question is almost always deliberate or at least reckless taking, right? Those look more like intentional torts, in which I have targeted and caused harm to an entity. Now, it is true, as Richard suggests, that there are aspects of IP law that draw on concepts from real property, just as there are aspects of IP law that draw on concepts from contracts and torts and criminal law. But that doesn't mean they are property, even though any more than it means that IP law is criminal law. Right? It uses some of the concepts. It doesn't mean that we have bound it to a legal or constitutional scheme. Richard spends a lot of time talking about the history, and it is true that courts in the 19th century would sometimes talk about IP in terms of property, though they were more likely to talk about it as a public franchise or a monopoly, right? Terms that sound, again, more like a regulation of the marketplace than like real property. And even the term intellectual property itself, which I have to confess is where I think a lot of this confusion comes from, is younger than I am. Now, that might not sound very young, but in the overall scheme of the country, it's pretty young, right? The idea that until the late 1960s, we weren't even really using the term intellectual property to describe what we're doing, I think is at odds with the idea that we've always kind of thought of it this way. One particular point to note there, Richard talks about the idea based on a now repealed statute, right, that once the Patent Office has sent this out into the world, the government is done with it and it can't take it back. He says, well, that shows that throughout history, it was only the courts that could do anything to revoke a patent. That history is wrong. In fact, it's close to backwards. In the UK law that we built at the foundation, the writ of surfacius was the way you got a patent revoked, and that required the consent and participation of the Crown. When we moved that to the United States, there was some debate as to whether courts had any power whatsoever to revoke a patent, or whether that power could only come with the participation of the government, because it was the government who had granted that patent. I don't think the rule was the reverse. That the government had no power under any circumstances to grant to revoke a patent. So I think on the second point, right, the law, right, has some commonalities with property law, but it is not property law. And finally, my third point is it's a good thing too. Even if you thought property theory could be capacious enough to cover virtually anything. And there are, like a closer analogy to what's going on here might be something like air rights or water rights, though those turn out to be really bad property rights. They're things that we actually had to impose a bunch of regulations on in order to sort of account for the fact that we had created a property system here. It's land and not air rights or water rights that property advocates are aiming for. Right? What property advocates want when they say IP is property is Blackstone's mythical sole and despotic dominion conferring total exclusion of the right on any individual in the universe. Now, Richard and some of the more thoughtful property advocates may not sign on to that sole and despotic dominion, but the people who are making these arguments are doing it in service of an agenda that I think doesn't fit very well with the realities of intellectual property. Property theory advocates have demanded of IP mandatory injunctions, and therefore a return to the days of hold-up and high payoffs for nuisance value suits. Preventing the Patent Office from re-examining patents once it's granted them. Richard mentioned that here. Even preventing judges from invalidating patents. The argument now is only a jury could do it, although that was profoundly ahistoric as well. Demanding punitive damages even for accidental infringement. Demanding criminal liability for patent infringement. And more generally capturing the full social surplus from an invention, something that no other part of our market economy allows you to do. Similarly, we see arguments for perpetual copyright terms. Mary Bono suggested forever less a day was the appropriate copyright term, and the like. I think these are bad ideas, but even if you think they're good ideas, we should support them after thought and evaluation of the evidence, not reflexively because we chose an analogy of property and we think that everything therefore follows for this. Understanding IP as regulation or as a government subsidy to support creativity gets us there. We don't forbid all regulation or all welfare, but neither do we say it must always be good. We can and should evaluate it with a critical eye. We should do the same with IP rights.
I did not know it was possible to make so many mistakes.
That's why I talk fast, Richard.
Well, yes, but fast. But let me just sort of start with a historical point. Thomas Aristotle says, I'm going to read a sentence from him in a brief on the oil state case. Records from the 18th century are unequivocal and demonstrate that juries decided the validity of questions, including novelty, at several stages in the life of the patent. Juries were tasked with determining validity during the infringement litigation, whether initiated in law or in equity during a court proceeding for revoking patents and sometimes doing patent prosecution. it was very clear that the dominant system in this case was always to use a common law jury in order to decide these kinds of cases. They were not advisory opinions, they were binding decisions which were then sent back in order to give an injunction. And then the question is, what sort of a nightmare did we start to have under these situations? And frankly, I mean, if it turns out that every time you think about this smartphone, you're thinking about 1 billion independent rights and that you're always trespassing on one or the other, it's certainly going to create a kind of a nightmarish set of expectation. But it turns out that property owners are not dolts. They understand exactly the same kinds of problems. And so what we do is we develop all sorts of arrangements that are perfectly consistent with having complex situations by having patent pools, friend arrangements, and agreements in one sort or another. And sure, you can find many cases in which there's going to be litigation with respect to the patent system. But what happens is by putting these cooperative devices in together, instead of having a little mosaic with lots of complexities, you just have a big final border at the outside. Now, Mark also referred to the fact, and I think he's correct, that there is an undue amount of patent litigation, particularly in recent times, but I think he's got the argument exactly backwards. You'll note that he said he's in favor of a system of regulation, but then he says, shh, I'm not going to tell you what that system of regulation is, it's only going to be prudent and wise. Well, it turns out that when you try to be prudent and wise in putting together a system of regulation, what happens is you have a kind of form of intellectual pea soup, so that nobody knows what the boundary lines of anything are going to turn out to be. What is surely the result of that kind of situation is a heightened degree of uncertainty, and this heightened degree of uncertainty created with this particular situation is necessarily going to create a situation in which it turns out that you start to get more litigation. So it seems to me that when you're trying to do all of this stuff, what you really have to ask is this system as crazy as it is? Then we are given the point about this being a tangible system. Well, one of the advantages of having spent my life as a medieval scholar dealing with various kinds of situations, it turns out property rights were always created in all sorts of things that were not land, not channels, not animals. The advows, the ability to point somebody to a church, was certainly protected by the writ of Darien presentiment when you looked at medieval law. Nobody ever wanted to say that it was a particular building. They said what it was a kind of office. You start looking at common law shares, partnership interests, inheritances, and so forth, and it would be very hard-pressed to say that these things are actually just simple physical things. They are, in fact, a complicated set of rights, and what we do in a property rights system is when we want to create a complex business, in order to make it a business that actually works, is what you do is you put all these things into a corporation, you give people fungible shares, so that what you can do is you can make market through the share side of the situation without having to say that every time I want to sell my share in General Motors, what I'm going to have to do is to convey to you a 452 millionth piece of 70 billion kinds of particular assets. So if you understand the transaction devices, all of this stuff turns out to be something of a mirage. You can do it. Then with respect to the injunctions, again, the point here is wrong. When you are talking about an injunction, that's the presumptive relief. The eBay test is completely wrong when it says it's always up for grabs. The basic rule is you can get the injunction with respect to the infringements. You don't have to prove deliberation. But if there are sort of complicated kinds of circumstances, there's always been in the equity practice, which gives you exclusive rights, an ability to tamper down a little bit on the injunction, to make it conditional, to delay it a bit, and then to clean up the situation by returning to a system of damages to figure out the way in which the system ultimately operates. So when one is trying to talk about this situation, it's that ability to have flexibility within the injunction space, which is a standard feature of equity courts, and that gets rid of the particular harms. The reciprocal risk, of course, is one that I think Mark does not talk about, which is extremely important. And I'll end on this note. You allow somebody to start to use, and then the only way you could get them is to sue them for damages on a repeated basis. What you're going to do is find out that opportunism runs in both directions and that the expropriation risk becomes extremely large. The moderate system that I'm talking about will do the thing to minimize both. The system which essentially waters down the injunction and makes it a mumble-jumble kind of game is going to create a lot of uncertainty. One wants to strengthen the eBay rule under these circumstances, and you also want to strengthen the category of property rights that are going to be protected, most notably with respect to various kinds of processes, Alice and Mayo, which we haven't talked about, which are much weaker. So essentially, if you mischaracterize the traditional system, you're going to, of course, condemn it. If you get it right, then in effect, the question is going to be, how is it you can show a system which is absolutely ad hoc is superior to a system which actually has clear and defined boundaries?
might be talking a little bit at cross purposes here, and that might be because maybe we have different understandings of what the debate is about. Richard, at various times, seems to take the position, and he did clearly in his opening talk, right, that IP is property. But what you heard mostly in the rebuttal was not IP is property, but, well, gosh, the current system of patents is not property-like, and that's bad, and we should try to make IP more like property. Right? Those are fundamentally inconsistent propositions, right? I think maybe he believes the latter and not the former. Right? If so, right, I think IP is not property. I think for various reasons it shouldn't become property, but that's a very different proposition than claiming that it is property. So let me just respond to a couple of things here. Did juries determine validity in the UK system? Yes-ish. That wasn't the original claim. The original claim was the government had no power to do it. Right now in our system, the government can revoke patents, and juries can also invalidate patents. That was the old English system. It was the common law system. And furthermore, it's worth noting that juries could defeat individual cases. They would let the defendant off the hook if they thought the patent was invalid. But those juries could not actually revoke the patent altogether. Only the government could do that at the time. Richard says we develop a lot of arrangements to solve the problems of 500,000 patents on a smartphone that I talk about, and that's true. What we do essentially is avoid some of the problems of property-like treatment by trying to contract around it, by trying to contract into liability rules, by saying all the standard essential patents have to be licensed to everyone on fair and reasonable terms, by saying we'll share. I don't think that means that we should move to a property regime, which seems to be what Richard is now arguing. To me, it's the opposite, right? Parties are voting with their feet to say we would like this regime to be as unproperty-like as possible. Richard worries that the boundaries will be uncertain. He points this out with respect to injunctions in this case, but I think the problem is that is our system, and it is our system in part because we have made it a property-like system, that we have tried to write patents that look property-like. Well, we didn't do a very good job. Now, it differs, it turns out, by industry, whether or not we can understand the boundaries and scope of patents. But I don't think it's right to say that boundaries are going to be any more certain if we declare these things to be property than if we declare these things not to be property. It is worth noting, and Richard has a capacious idea of things that can be property claims. He talks about the grants of rights to medieval clerics. But it's worth noting that, right, the claim to property has been used to assert a lot of different things that seem crazy by our standards. Right? So Morton Horowitz attributes to Blackstone the idea that competition between a mills or bakeries or river ferries could be enjoined on property principles. After all, I have a right to this market, and you have interfered with my market. Yochai Benkler cites the same with respect to a property right to the East India Company in trade with the East Indies. Larry Lessig talks about the free riding arguments offered by property owners in the 19th century, that they were entitled to prevent photographs of their property because, hey, it's my land, you can't take a picture of my land. Now, part of this is, as Ben Kaplan put it, there's property and there's property, with few, if any, legal consequences extending uniformly across fields. So part of our disagreement might simply be, what is it that what's the proper regime? But I think what's notable here is that the proper legal regime has to be a function of what does the universe look like? And the universe of intellectual property and the things it covers looks very different than the things that we traditionally apply real property or personal property rules to. So if he wants to call it property when it looks nothing like property, I guess I would be not so upset about that, except that I think that calling it property makes everybody's mindset go to land. It makes everybody's mindset go to the despotic dominion. It makes us think, well, injunctions should be mandatory. These rights should be quite broad. Richard finally worries about the opposite. What if we grant too weak a system in our regulatory structure? Lots of people will steal. Lots of people will copy. I have 2 points to make there, and then I'll close. First is that that's not what the patent system looks like. 98% of the lawsuits filed in the patent system are not against anyone even accused of copying. They are against independent inventors. They are against people who developed their own idea, their own invention, but they had the misfortune to do it at the same time as someone else who later went and got a patent on it. In the rare cases where that's not true, we have a system for punishing deliberate infringement. We allow you to get treble damages against anybody who has willfully engaged in infringement. So the system we created via regulation does not look very much like a property system, but it does look like a system that's more or less well-tailored to the unusual circumstances of patents.
So, thank you. I think that was a fantastic airing of the opposing positions, and I wanted to maximize engagement and talk and discussions with the audience. So I'm not going to exercise moderator's privilege. I'm actually going to ask if anyone has any questions of our two debate participants.
Do we have a floating mic or anything?
Yes, I believe I saw one earlier. Yes,
there's a mic.
Yes,
and this is being recorded, so maybe.
Make sure you wait. Yes. So I see someone in the back, and Jonathan, did you? Yes. Thank you very much. I turned it on, so it's ready to go. So just the gentleman right there in the blue shirt in the middle.
Thank you. I have a question for Professor Lemley. You talked about what the system should be. You never really answered Professor Epstein's first point about securing the exclusive rights to their invention.
Yeah, it's a fair point. So I think Richard helped answer his own point in his own original speech. So while he points to secure to authors and inventors the exclusive right to their respective writings and discoveries, which is what the Constitution says, he admits later on in his talk that we're not actually just securing some pre-existing natural law right. That there is no patent in nature, that we are in fact creating a new legal regime in order to give people a particular power over something that didn't exist before. So I don't think securing can mean sort of locking down or cementing something that's already there. Now, he may mean something different by that, right? Which is, well, gosh, in order to be secure, I have to be sure, right? It has to be certain, and my rights and powers over it have to be sufficiently robust. If that's right, I don't think we've ever had a property rights patent system because it has always been the case that you can and do challenge patents in court and invalidate them. You can, and it is hard to figure out whether or not what the defendant is doing is within the scope of the patentee's rights. Patentees lose 3/4 of the suits that they bring when they go to judgment. I don't think that's bad. I think that is a kind of necessary function of the uncertainties inherent in trying to take words and map them to new inventions. Right? It's just hard. And we screw it up a lot, but we therefore need a legal system that responds to screwing it up a lot. And I think just declaring, well, the patent office said you can have this patent, and therefore we must give you secure rights in it, I think is a recipe for disaster.
I disagree. I think the words that are there meant what they said, which is the object of Congress is to figure out whatever system it wants. But the question is, do the rights become vested once it turns out they're transferred? And that's always been the conception of property with land and everything else, and that's what's here. Well, when you issue a grant, does it necessarily mean that it's inviolable? The answer has always been no. These grants could be set aside on grounds of fraud, undue influence, actions beyond the scope, but it's always been done in a judicial format. So the thing that one has to understand is, there's certain kind of idiosyncratic features that are associated by patents, certainly in the nature of the rights and so forth, but you're never going to be able to get things right if every time you say, this is the system of regulation, you start over with some kind of an ad hoc solution instead of asking yourself, is there any relevant difference between a patent and something else? And here the notion of exclusive use is very much associated with land. It's not associated with water because it's a common system and so forth. But where it does apply, I think you want to extend it. Where it doesn't apply, you don't. But as far as I'm concerned, you do not secure a system of property rights if the moment these rights are created, somebody can say, oh, the guy gave it, you take it back. And oh, by the way, when he enforces these kinds of things, he's not going to protect you in the right as a presumptive matter. It's just going to be the question of what? So ask Mark the following question. You grant the patent, and what you announce with the patent is the maximum amount of damage that you can recover in the event of breach is $1. Is that a constitutional statute or not? If you've got plenary powers, you can do this. If you take the limitation of unconstitutional conditions seriously, you cannot.
So I actually, that's a fair question. I think the answer is absolutely you could do it. I don't see why you'd want to.
I rest my case.
Okay, well, good. So to be clear, Congress did not have to pass a patent statute at all. Right? Congress did not have to pass a patent statute that applied to any particular technology at all. And indeed, for much of the history of the country, certain kinds of things were subject to patent protection, but others got no protection whatsoever. I don't think that you can take this idea of unconstitutional conditions and conclude that you could, in fact, decide not to grant any patents to a particular technology, or you could grant them subject to various limitations, but once you grant them, you've got to give a full panoply of property-like rights to them. There's nothing in the Constitution that says that.
The doctrine of unconstitutional conditions applies everywhere and anywhere. It is not written in the Constitution, but there has never been a regime which has been able to work without it. The way to understand this is that when the government has powers, got monopoly powers, there are real dangers of abuse. Mark referred to the situation where you gave outrageous patents for franchises and so forth. Those were classic illustrations of suppressing competition by the creation of monopoly, not creating exclusive rights and something you invent in order to facilitate a competition. And the whole doctrine of unconstitutional conditions is the effort to try to constrain the way in which monopoly power is used. And that power cannot be used to say, yes, I'm going to grant you a patent under this particular thing, and by the way, the only remedy that you get is a single dollar. Congress cannot do that. If it's going to give you the right, it has to go the whole way. And what Mark said makes the point. They're not going to chisel and stop on a patent system. So what you've done, in effect, by showing that the option of doing nothing is unpalatable, what you do is you drive Congress into a system of robust property rights. And these are rights which you can vary by contract. Property and contract are not in opposition to one another. Essentially, contract rights are the way in which you manipulate property rights through joinders. So the pools are only possible because you have property rights. They would never be possible if you did.
Note where the rabbit...
Mark gets the response, and then I want to go back to the audience.
Note where the rabbit goes into the hat here. Why is this condition unconstitutional? It's unconstitutional because it's a property right. But that's the very thing we're trying to demonstrate here.
Because it's crazy and inefficient, consistent with...
Believe me, Richard, I wish we lived in a world in which crazy and inefficient made it unconstitutional, but we don't.
Unfortunately, what happens is, as you said, it doesn't today. That's a condemnation of the current system.
Richard,
you come to a debate, and now what you're supposed to do, I'm going to defend the crazy and inefficient because it turns out it's efficient. That is point number 3 of his speech. Cannot survive this last.
Mark, you do get what you get a response, and I do want to go back to the audience.
So I do think the unconstitutional conditions idea presupposes that this is a property right, and therefore that I get the property remedies, which is the very thing we're trying to establish. The one thing I will note about treating it as property that we haven't yet talked about is this idea of a taking. Right, and of the one-way ratchet. Right, if you declare this to be property, then, as Richard says, well, the government can once make a decision, either at the individual case to grant you a patent, or at the broader case to grant greater remedies, greater rights to a patent. But it can only ever go in that direction. Right? It can never actually turn around and change its mind, because to do so would be to take away the thing that we had secured. That strikes me as a bad idea in a system that is essentially trying to regulate and create incentives in a complex market economy.
So I saw a question over here. So press your left. I'm going to make Jonathan get some exercise. I want to make sure we're touching on all aspects of the audience in the room.
Great, thanks. So I'm curious whether you would both agree that the answer to this question depends on empirical facts about the world. And Richard, I know you've told me you're not an empiricist, but you made a bunch of empirical claims in your statement, like that it's more efficient to have the courts be the only ones who are taking away patent rights, or that in practice there are the 500,000 whatever patents on a smartphone, there are efficient market structures that have developed to deal with them, and that granting injunctions is going to generally be more efficient. And so and Mark's third point was focused on the way things are actually coming out in practice. So would you agree that like if Mark's vision of how the patents and other IP systems are working in the world are, that would have a different question than save for Mark and the reverse?
I don't. So let me give you. First of all, when we start talking about empiricism, I certainly believe in general tendencies which say to the effect that if you do not give people incentives to produce, they're not going to be able to produce. What I'm very much opposed to is an argument which sorts of look at a particular industry in a particular way, do an exhaustive field study, come up with an inconclusive result, and expand this wide, and then use that to indict the entire system about patents. If you're going to talk about the patent system, you have to talk, it seems to me, about generic effects. You cannot be talking about these particular ad hoc cases. Second point is, suppose it turns out that what you can do is you can show that a given distribution of property rights is systematically inefficient. Does that mean you're absolutely hopeless? No, if you understand when I developed my book on takings, right, there was a notion of implicit in-kind compensation which was part of the book. And what that said is if you've got an inefficient distribution and you can convert it to some other distribution which is Pareto superior, you don't have to pay compensation because it comes in kind. So if you want to talk, for example, about the transformation of property rights in land in order to accommodate overflights by way of airplanes, the answer is you don't have to accommodate anybody by paying them for flying high. But on the other hand, when there's a disproportionate burden associated with flying down very close to somebody's house where you disrupt it because you have to land, you do pay that. That's exactly the kind of system that I would apply in the other case, and this just reinforces the basic point. Land is not nearly as simple as the conception that Mark put forward. The notion of implicit in-kind compensation and Pareto improvements by general judicial or legislative claims applies there, and there's no reason why you can't apply to the patent space as well. But you've got to show what it is. A statute of limitations, for example, or a statute of frauds has exactly that kind of rationale. And so when the question was whether or not a statute of frauds was unconstitutional because it was an impairment of the obligation of contract, the correct answer is to say it does impair contracts, but it also makes contracts stronger, so the protections you get from predictability more than outweigh the particular losses that you get from having a very uncertain perpetual claim.
I'm not sure if that was a yes or a no.
You do it intelligently. But you don't do it on an ad hoc basis. I think principles.
I think we are in agreement on that point. I mean, I'm a very strong believer in empirical evidence. It's certainly right that we want it to be sort of system-wide, and we also wanted to have the flexibility to account for the fact that the story I told about the smartphone is actually very different than the story that exists in the pharmaceutical industry, right, where I think there's a much stronger case for stronger patent rights. The one thing I'll say is, right, it may depend on whether the question is or ought, right? So if the question is it property, I'm not sure that's an empirical question. That might be a kind of legal question in which we look at sort of the history, in which we look at the doctrine and say, how does it compare or not compare to other kinds of property? If it's should it be property, yeah, I do think that's ultimately a question that depends on our assessment of what does the world look like.
Lisa, when they decided to create property rights in land because of the agricultural revolution, this was a huge transformation, right? Because it used to be usufruct rights and nobody could do anything. But the overall gains were so enormous that you don't worry about distributional consequences. And that, if in the water rights area, the coffin against the left-hand ditch company, if you know it, was explained how it is they switched from repairing to prior appropriation, because the net output was 100 times as large. Distributional consequences when you get gains that large are just not worth worrying about. But in most cases where things are less dramatic, you do want to worry about them, which is why we have a takings.
Part of my worry is that right now a large percentage of the patent system seems to me to be the equivalent in Richard's example of a bunch of people in Kansas suing the jetliners flying 35,000 feet overhead and saying, hey, you know what, I know you didn't know I was there, I know I didn't actually contribute of anything of value to you, but look, you're over my property and so I want a chunk of the value of your plane. We can fix that. I think we actually have been doing a decent job of trying to fix it in the patent system in the last 10 or 15 years, but we fix it precisely by going away from the things that make a system property-like.
The air rights cases were trivial infringements and massive social gains. There's no way you could describe the changes in the patents that are conforming to that.
I think the patent troll who sues these people is a great example of trivial and innocent infringement for a massive social gain.
Some of us have a different view. What you call a troll, we call an enforcer. In fact, what happens is if the rights are valid, you should be able to separate them in assignment for efficient enforcement. The question is not whether he's, quote, troll or not troll. The question is whether the claim is valid or not valid. Anyhow, Stephanie?
I will, there's a questioner back here. So.
Hi there, thanks, Melissa. I find in the industry there's 3 high school debate, 3 activity that are curious. A lot of entrepreneurs in technology opt to not file patents but go for trade secrets. Another is the clothing, footwear, and textile or fashion industry, where you cannot put copyright or patent on pants because more than one person needs to make pants. But as a consequence, there's massive diffusion, which is literally copying. And then thirdly, I do really appreciate the constitutional reference, especially protecting originators. However, I thought it's curious Google's attempt to blur that through putting author's text on without reference.
Through putting author's text. I got it. Okay, yes.
You heard the question more clearly than I, so you may answer first, and then I will explain why I think it's incorrect.
All right, so 3 parts to this. So people getting trade secrets instead of patents. That can happen, although it's worth noting that it seems to happen almost without regard to the strength or weakness of the patent system. So in industries where it's actually easy to keep a secret, people almost always opt for secrecy, right? If my invention is the kind of internal workings of the factory, people opt for secrecy whether you have a strong or weak patent regime. For all of the claims that in the last 10 years we have weakened the U.S. patent regime and we're destroying U.S. competitiveness and so forth, it's worth knowing that the number of patents keeps going up, right? We have more patents filed, more patents granted than ever before. We have twice as many as we had in the 1990s, the so-called heyday of the patent system, 3 times as many as in the 1980s. So it's a worry at the margins if we think we're going to lose information. We also need to know whether or not the patent's actually giving us useful information and disclosure, and that's another discussion. The third was the Google book search. So I will disclose my bias here. I represented Google in that case. So I think we were right to do it. What I will note about that case is the ability to actually find snippets of books online was something we didn't have. It was something that no publisher was planning to give us. There were no plans to do it. Google went ahead and did it despite the risk of actually even Google crushing liability. If they had lost, the statutory damages minimum would have been something like $8 billion, and the maximum would have been, something close to the GDP of California. And they did it, and I think the world unquestionably benefited from that. Right? We have access to information we would not otherwise have had access to. The publishers who have their books still in print ended up signing deals where they could then link those search results to, hey, why don't you buy our book? The ones that are still not in print, which no one would otherwise have found, the world gets access to. Your middle point, I confess that I have lost for a minute.
I don't remember it either.
I think footwear and textiles or
yes,
fashion,
yes,
diffusion.
Yeah.
And I'll just add a little bit. So because of that openness, it's more profitable even than technology historically, cumulatively, because of no patents.
Right. So what's interesting about clothing. Well, 2 things interesting about clothing, right? One is it is right. You have fast copying. Right, because you have not traditionally had intellectual property rights. People have gotten on the market pretty quickly with knockoffs. That has coexisted with a pretty valuable and profitable brand industry. Part of that is the name and branding, but part of it is that it has actually driven fast innovation. Right? You can't actually keep the same pattern around for a long time if someone's going to copy it and it's going to get knocked off soon. Now, we just 3 years ago changed the rule so that now you can copyright your clothing patterns. I think that opinion is a disaster as a matter of copyright law. It remains to be seen whether it will be a disaster as a matter of economic policy. But it is worth noting, I think, that we had a pretty vibrant clothing industry in a world that didn't have intellectual property protection. But we have nonetheless decided to sort of create it anew in the last couple of years.
Let me give some responses. One is respect to trade secrets. I agree. I think virtually everybody agrees it's a perfectly sensible alternative to patents. You should be very aware of double protection. First, you try to do it as a trade secret, and then you do it as a patent because of the risk of the overextension beyond the kind of limited times that you want. I do think, on the other hand, that in many particular cases, if something is more efficiently done by a patent and you make the patent system less efficient than it ought to be, going to a trade secret is going to make things a little bit harder because what happens is you have to enforce confidentiality agreements, you run the loss of catastrophic losses and so forth. So I'm perfectly in favor of a divided economy, but I think you have to move it. On Google Books, I mean, I actually sympathize with Mark on this thing, although I didn't represent anybody in the case. But essentially, it's exactly the same kind of argument that I made with respect to the air rights. That is, if you look at the two classes of books, those are long out of print by nobody. Essentially what happens is if you have a search mechanism that allows you to find an obscure copy in some library and read the book and do the author, you're doing the authors a favor under these particular situations because that information now gets out where it would otherwise be lost. So I think, in effect, the implicit in-kind compensation model that I referred to does a fairly good job in explaining that. And then with respect to the newer ones, I think the correct answer to this particular situation is what Google should have said, hey, these things are really online now. At this particular point, what we do is instead of just doing it unilaterally, what they should say is for books that are currently in stock, what we will do is give you this author, and what will happen is you'll get the bargain. It's a kind of a Kosian type situation. The efficient solution is this one. If you put the property rights in one direction, it may be that Google gets too much money, in the other case not, but that is not going to be a disaster.
And that's what they did, by the way.
Yes, which is, this is perfectly consistent with the framework that I talked about with you. The third case on the patent stuff, there's a long history about knocking things out of the patent system for one reason or another, and then having particular statutory fixes that put these things back. And fashion, of course, is one of these things. There was an effort to try and protect various kinds of fashions by refusing to sell to people who did not decide to honor the fashions of somebody else. And then it turned out that became an antitrust violation in the 1940s. In a case where I think Justice Hugo Block got it exactly wrong. He said, well, this is a restraint on trade, but he didn't talk about the particular justification associated with it. And when you start to create the kind of property rights, this happens all the time. Bonito Boats is another information with respect to the reverse mold is using for somebody's hull. This is not going to be a case of 10,000 moving parts and so forth. It's just a common way of cheating. They refuse to protect it judicially, and then what somebody does is it comes up with a statute. So I think the fashion is too. I do think that there is a tendency, which I regard as mildly supportive of the position that I have, which is to say the courts become very skeptical about creating new rights. If you recall what was said in the Doris case by Learned Hand, we're not going to take INS and extend it 1 degree further. I mean, it just showed he didn't understand what INS was about, and then he kind of made a wrong sort of decision. So whether or not the ultimate verdict is there, I think as a matter of legal policy, protecting these things is going to be appropriate. The question you have to ask is the one that Mark asked, is this thing going to completely wreck a particular kind of market? At which point, then what you start to do is to figure out whether or not there's some other kinds of adjustments that you could start to make. You don't want to do this with the grand problem that I've had. First, these things are done with this one, but certainly what you do is you preserve the degree of flexibility with respect to future designs. So if you want to change the statute, given the very rapid turnover that you have in the saleability of these designs, I think you could do it consistent with the strictures of what I said.
I was very concerned 2/3 of the way through that we were going to be in complete agreement.
Well, don't worry about that.
But so I actually agree with almost everything there. The only thing I will say is the Fashion Originators Guild case, the antitrust case that Richard mentioned, seems to me exactly right. Whether or not we should government grant IP rights in fashion, the idea that private parties should be able to create their own IP rights by colluding to not do it seems a really bad idea.
Well, the reason why it's such a good idea is that what is you're trying to ask yourself the same question before, is this a Pareto improvement over the generalized enforcement of the antitrust law? And even though we call this a per se violation on the horizontal side, there have always been various kinds of exceptions for coordination and so forth. So the issue is how per se the per se is, and it's just wonderful. Mark accuses me of being dogmatic and absolute on property rights, and now when it turns to antitrust, we know who has all the flexibility and who has the regrettable rigidity.
Yeah, I'm all in favor of Pareto improvements, Richard, but I don't think that word means what you think it means. There were a lot of people who lost out, right, in that system, and that was
I'm going to.
Let me put it this way. I'm comfortable with my use of that in this particular case because it becomes hopelessly ad hoc. If you say, when we have any general reform, which raises Apostolata. If you could kind of find the one Rawlsian guy who's worse off, you just ignore it. When we talk about Pareto improvement in the world of practical affairs, we mean large, general, aggregate stuff without any targeted.
I think you want Calder-Hicks efficiency, but that's a footnote.
There's a questioner waiting right over here, Jonathan. Yes.
Wait, make it
Yeah.
Stephanie doesn't
No,
know my
but well, no, you do because we're
so.
recording it. So yes.
Come on, Stephanie. That's without an E at the end.
I'm just a poor country lawyer. No. Silicon Valley patent lawyer. But Professor Lemley, it seems that if we took your argument and we applied it not in comparing current patent rights or intellectual property rights to how they could have been or what they are, but instead did a comparative analysis and went somewhere else in the world where property rights are extremely poorly defined, the boundaries are uncertain, nobody knows what's going on. You walk through a part of the bush and you have no idea whose property rights you're encountering or how they're going to be enforced, if it's going to be death or if it's going to be a bribe. And we compare that and someone says, look, property rights there in land do not look like property rights in land in the United States. And we would take that to be a condemnation of the way that regime established property rights in land. And we would, again, it's a question about what institutions and rules are put over land. It's not a property of the land itself. It's not a characteristic of the land itself. And it seems like your argument could be applied to say that land in those countries isn't really property, and that's not what. And so my reaction is, how does your argument not apply to land in areas of the world where property rights have not been properly defined and the meets and defines are not certain?
So maybe I was unclear, but I think my argument is pretty close to the opposite of that, right? So my argument is the fundamental characteristics, the economic characteristics of the things we are defining as IP are fundamentally different than land. And so a legal regime that works well for land, right, which I agree that our property system generally does not necessarily work well for that fundamentally different characteristic. So the fundamental economic characteristics of land don't change there. And so I think it is right to say land in the developing world should largely be subject to a set of property rules that's not all that different than ours. There may be reasons to think there are different ownerships, there are different sort of sets of prior entitlements or who knows what. But I think my argument is kind of the opposite of that, right? That if we thought patents had the characteristics, the economic characteristics of these things were similar to the economic characteristics of land, I'd be fine with a land-based property system. But I think they don't, and so I think having a land-based property system and just trying to rotely apply it onto those very different economic characteristics is a bad idea.
To answer the question a slightly different way, one of the problems that you have with all these primitive societies, particularly with what they call rural land in China, that is land which is all divided so that you can't get development on there, is how you could change the regime. But interestingly enough, you cannot change it by simply wiping out the rights of the small individuals, any more than you could do with the system of enclosures, which English had. And so what you need to do is to develop a device which you use also for land when you want to get common improvements, which is something on the nature of the special assessment. So what you do is you find a community, you put it together, you announce that everything is going to be pro rata with respect to value, and then what you do is you let this decision go up or down by a rather supermajority vote. And that's exactly the system that was proposed by one of my students, Roy Ying Chen, who's a leader in the sort of the reform of the rural lands with respect to China. The other point to make is Gary Leiberkap and others, Dean Luke, have done studies of what's going to happen to the value of land if you do it by meets and bounds or by the tree here and the something there, as opposed to a survey. And basically the value of land goes down by 25 to 30% when you have indefinite boundary lines. I think that's also going to be true with respect to intellectual property. So the way in which I would put the point is once we know in dealing with land that fuzziness is deadly, what we really want to do is to maximize the level of clarity that we can possibly get. And you're not going to do that with a heavily set of discretionary rules. You're not going to do that with a set of rules, for example, as you well know even better than I, in which when you start talking about various kinds of business method patents or inventions and discoveries and processes, what you do is you put all those things into the public domain. We have not talked about this yet, but I regard two of the greatest menace decisions in the history of patent law as the Alice Mayo line of cases, because I think that really has developed a very serious retarding effect on forms of medical technology. Are we done in time, Mark? Or
I think one more question.
We have a
probably.
few more minutes. We have time for one more
Can I ask
question.
a question?
Oh, sure, John.
You have the microphone.
Jonathan, you have a property right in the microphone.
Thank you very much. I feel like I'm in kindergarten. You passed the talking sticker. So it's my understanding that patents and copyright are passed with congressional authority under the IP clause, which Richard quoted before, but trade secrets and trademarks are congressionally passed under the Commerce Clause. Should the actual congressional authority affect how we view whether these things are property rights or not?
No. Let me give one of the cases we haven't talked about is Ruckelshaus House in Monsanto, which is an unconstitutional conditions case. And so what you do is you have the rodenticide statutes and things like that, and what you have to do is you have to get them approved. And the question is, can Congress just attach any condition that it wants with respect to these things because it's done under the Commerce Clause? The answer to that question is it should be a resounding no. So when Harry Blackman, in a very dreadful opinion, says, yes, trade secrets like this are property rights, but by the way, Congress can condition the license to sell it in the United States on anything that it wants, including giving the information away for free to your competitors, that opinion has been roundly roasted precisely because it ignores that particular problem. And the same thing is true with the Commerce Clause and Hammer and Dagenhall. You have a situation where you say, yes, you can sell your goods in interstate commerce, but you can only do so if you agree to pay minimum wage laws, get rid of child labor laws, basically put all sorts of things on the manufacturers. My view is the doctrine of unconstitutional conditions says that you cannot dominate the system there. And I'm talking here not about made-up law. I think it's as generally widely accepted as being a problem. So I don't think the change in the source of the doctrine does it, because as I said at the beginning, unconstitutional conditions is a ubiquitous doctrine. You name a clause, if it confers monopoly power, the implied conditions are going to be attached to it.
And since Richard began the talk, I'm going to give the final word of the debate to Mark in both responding to the questioner and to Richard's remarks and giving the final statement.
So I think you can create an IP regime under any sort of constitutional basis. I do think it's worth noting that Richard's argument at the beginning of his talk, right, about secure and exclusive right and all that stuff just went out the window, because he just told you can have exactly the same IP regime without any of that constitutional basis in something that's based in the Commerce Clause. And if you can declare anything you want to be a property right using the power of the Commerce Clause, we can declare any of the kinds of things we used in the 19th century to be property rights. I don't think we should.
I didn't say that.
And
I'm done.
Well, thank you both.
It's never dull.
Excellent exchange of views. Really appreciate both of our intellectual pugilists. And thank you all for coming. And we will be posting the video online so you can all then take dubious notes, copious notes, and follow actually everything that was said. Thank you.
Thanks, Adam.
Thank you.